Hi, everyone. Welcome to Disability Discrimination and the Rationing of Life-Saving COVID-19 Treatment, Who Gets Left Behind. This webinar is sponsored by the ABA Commission on Disability Rights and Section of Civil Rights and Social Justice, and this panel is one of many in a series of rapid response webinars on the COVID-19 pandemic. During today's program, we encourage you to ask questions. You should see a control panel with controls such as audio options, chat, raise hand, and Q&A. For the purposes of this webinar, we ask that you submit your questions through the Q&A, not the chat function. We will address questions at the end of the panel. We will be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. Please feel free to leave us feedback or ask questions for follow-up. My name is Shira Wachschlag, and I'm the Director of Legal Advocacy for the ARC. Our other presenters today include Jennifer Mathis, Director of Policy and Legal Advocacy for the Bazelon Center for Mental Health Law, David Carlson, Director of Advocacy for Disability Rights Washington, Ivanova Smith, Chair of Self Advocates and Leadership, Alison Barkoff, Director of Advocacy for the Center for Public Representation, and Samantha Crane, Director of Public Policy for the Autistic Self Advocacy Network. Before we get into the weeds of the legal analysis and the various complaints that have been filed, it will be helpful to have some basic background on COVID-19 treatment rationing, as well as the broader concerns about disability discrimination in the medical context. In mid-March, we started seeing media reports that Washington state officials were discussing the possibility of rationing care in the event of a shortage of medical equipment and personnel. In response, on March 20th, a coalition of disability rights groups, including many of those participating on this call, sent a letter to the U.S. Department of Health and Human Services, Office for Civil Rights, which we'll refer to during this webinar as HHS-OCR, in case you hear that abbreviation. The letter was sent to ensure that if the current pandemic results in government decisions to ration treatment, decisions about how medical treatment should be allocated are made without discriminating based on disability. The following week, national and local groups, including those on this call, partnered to file 4 complaints concerning disability discrimination and treatment rationing plans with HHS-OCR in order to further highlight the specific concerns about these plans and the urgency for HHS-OCR to issue guidance to states on how federal disability rights laws apply here. The first complaint was out of Washington, which had been one of the epicenters of the epidemic. This was followed by complaints out of Alabama, Tennessee, and Kansas, and more recently, Utah, Pennsylvania, and New York. Every plan is different, but some of the problematic criteria within the plans, which will be discussed in more detail later in the presentation, include categorical exclusions from treatment on the basis of disability diagnosis, quality of life assessments in place of objective medical evidence, long-term survival speculation beyond the prognosis for COVID-19 treatment, failure to provide for reasonable modifications in receiving treatment, including allowing for longer time on a ventilator, reallocation of the ventilators of chronic ventilator users, and overall failure to provide for a thorough individualized review of each patient to avoid decisions made based on diagnoses and stereotypes. In addition to the specific concerns with the crisis standard of care plans, there's a long history of disability discrimination against people with disabilities in the medical context that is necessary to understand as a backdrop here. As outlined in the Washington complaint, concerns about disability discrimination and receiving medical treatment are not new. Studies have repeatedly documented a persistent bias by medical providers and bioethicists against people with disabilities and a failure of medical providers to fully appreciate the value and quality of life with a disability. These problems are reinforced by the dramatic underrepresentation of people with disabilities in the medical profession. With medical discrimination, the provider may not view their actions as discriminatory and claim or believe that they were trying to do what was in the patient's best interest. But people with disabilities have been denied and continue to be denied treatment because of improper decisions based on implicit biases about the quality of life and inherent worth of people with disabilities. Accordingly, research has shown that patients with disabilities experience healthcare disparities, including lower rates of screening and more difficulty accessing services compared to people without disabilities. Disability advocates have been fighting against this bias for decades to ensure they can receive equal access to life-sustaining treatment, and we are continuing this work in challenging COVID-19 treatment rationing plans nationwide. Today, we're going to get into more detail on everything I just mentioned. Our presentation will include a discussion of the legal framework that applies to treatment rationing plans, some of the state level advocacy efforts that we've taken, the complaints submitted to HHS OCR and the agency's recent guidance, resources for advocates, and then a question and answer with the audience. So first, we're going to hear from Jennifer Mathis, who's going to discuss the legal framework.
Hi, thanks, Shira. So I'm just going to give a little bit of background on the various federal laws that apply here and talk a little bit about how those laws apply to the particular situations that we're seeing. And then others will talk in more detail about how they apply in the complaints filed and in the guidance documents that have been done for folks. So I think you all can guess that the ADA, the Americans with Disabilities Act, certainly is one of the core legal protections here. I just want to start by saying that the fact that we are in the midst of a pandemic does not mean that the federal disability rights laws don't apply. I think there were some suggestions from some quarters that maybe, these civil rights laws in some way were diminished or didn't really apply because of a pandemic. And in the guidance that was issued by the federal government that Shira referenced, the HHS Office of Civil Rights makes clear that these laws continue to apply, pandemic or not. And so the ADA, it's mainly Titles 2 and 3 of the ADA that apply. Title 2 applies to public entities, state and local government entities, and that would include states that are promulgating rationing policies for how to allocate scarce medical resources, public hospitals, public healthcare facilities. Title 3 of the ADA applies to privately run public accommodations. And so that would apply to healthcare facilities that are private, including private hospitals and ICUs that are implementing rationing protocols. Section 504 of the Rehabilitation Act also applies to pretty much all of the same entities. Section 504 applies to healthcare establishments that receive federal financial assistance, states that receive federal financial assistance, and actions of the federal government itself. Section 1557, which is the non-discrimination provision of the Affordable Care Act, applies to healthcare establishments that receive federal funding from HHS or are administered by HHS, health insurance marketplaces, and plans offered by issuers who participate in the marketplaces. So these laws apply essentially to the states that are developing and designing and promulgating, issuing these rationing policies, and the healthcare providers that would be implementing them if they do end up going into effect. So some of the core legal principles that apply here, the most core principle is individualized assessment. That's, I think, the most core principle of disability rights law. An individualized assessment has to be done based on the best available current medical evidence and not based on generalized assumptions about a person's disability. So when you are making decisions that affect people with disabilities, like decisions about who is qualified for treatment, you have to do an individualized determination and not simply make presumptions based on someone's diagnosis or someone's falling within a general category of condition or disability. A covered entity can't presume that somebody is not qualified to receive treatment based on a disability diagnosis without that kind of individualized determination. That includes presumptions based on judgments that somebody's disability might impact their quality of life in a negative way. That includes presumptions that somebody's disability impacts their prospects for long-term survival. That includes presumptions that somebody's disability impacts the intensity of resources that are required for that person to receive treatment. So you can't be acting based on generalized assumptions about a person's disability, and the protocols that are designed can't be designed based on those kinds of presumptions that if somebody has X condition, X diagnosis, that means that that person is not going to be a good candidate for COVID-19 treatment. Denials of treatment, I think what we've seen is that denials of treatment in these protocols, the protocols sometimes enable those denials of treatment to be based on either outright exclusions based on someone's disability, or that they simply negatively weight someone's disability. They consider it a negative factor, it counts against the person. Both of those types of determinations, whether it's an outright exclusion or whether it just counts against you, if it's based simply on a diagnosis or the fact that you have a disability, that is not lawful. That is not an individualized determination that looks at your particular circumstances. Who is qualified for treatment, I think, is really one of the most important issues here as a matter of law. Whether a person's qualified to receive treatment should be based on whether the person can benefit from the treatment. This is COVID-19 treatment we're talking about. That's the thing that is being rationed, whether it's ICU beds or ventilators or other supplies for COVID-19 treatment. If that is the benefit that's being provided, then whether someone's qualified should be based on whether they can benefit from that treatment. And that means whether they can survive that treatment, whether they can survive in the near term. If somebody is not going to make it through the treatment, or if somebody is likely to die in the next week, then sure, that person might not be qualified to receive the treatment. But beyond that, somebody's disability really should not come into play in terms of whether that person is qualified. The determination should be about the treatment itself. Now, one might say, well, this is a pandemic, and so we get to set other kinds of qualification standards. So it's fair to limit, because we have to ration, we get to say that, in fact, we can further limit who's qualified to receive treatment. And that can be true, that you can have other types of criteria to narrow who is qualified. People have done lottery systems, people have prioritized healthcare workers, people have done first come, first serve policies. There's a variety of different ways that you can allocate treatment that are disability neutral, that don't base being qualified on having a disability. But you can't you can't put disability or the absence of a disability into being qualified. And that is based on Supreme Court law. So you can't say that somebody's only qualified to get COVID-19 treatment if they don't have certain types of conditions or certain disabilities. That would be discriminatory. Some of the types of discrimination that occur in this context that you will see in some of these protocols are protocols that do consider people's prospects of long-term survival. So based on a pre-existing disability that the person has, having nothing at all to do with whether this person can benefit from COVID-19 treatment, whether this person can survive that treatment and get out of the hospital. These rationing protocols sometimes look at people's ability to survive into 3 years, 5 years, 10 years from now, and they look at people's diagnoses and people's conditions to make those determinations. That is denying treatment based on a disability to someone who's otherwise qualified to receive the treatment, can benefit from the treatment, can survive, and that we believe is not lawful under the ADA and the other disability discrimination laws. Another thing that you will see in these protocols is determinations that are really about quality of life, that negatively weight or outright exclude people with disabilities from receiving COVID treatment because of value judgments about those people's lives. So for example, one of the complaints was about a policy in Alabama. This has now been resolved, I think Alison will talk about this a little bit more, but in Alabama, the policy said if you have a significant intellectual disability, that you would not get a ventilator. You were not a good candidate for a ventilator. And so that determination, that it was not about somebody's prospects for survival, that was not about whether somebody would be able to make it through the treatment. That was about really a judgment about the quality of people's lives or the value of people's lives. That is no longer in effect, thankfully, but that's an example of kind of a quality of life determination. In addition to that, there are, I think, reasonable modifications that should be made. That's another principle of law. In these policies, you will often not see references to reasonable modifications that could be made, should be made, that the ADA and 504 and Section 1557 would require, excuse me, reasonable modifications to the usual policies and practices required to ensure equal treatment for people with disabilities. And so those might include, for example, interpreter services if somebody needs interpreter services at the hospital, if somebody needs a family member or a direct service professional to be present, even though ordinary rules might not allow it. I think here there would have to be protective equipment, but that would be an example of a reasonable modification, is allowing a family member, service provider to be there with a person, even if that is a modification to the usual rules, the usual way of doing things. In addition, modifications may include changing the way that the treatment protocols work. So for example, if somebody is typically allowed to be on a ventilator for say 2 weeks before the docs start deciding that maybe now it is time to give up and to take the person off because they've had sufficient time to recover. If someone has a disability, that might mean that they need a little bit more time on a ventilator to recover, then that might be a reasonable modification to the treatment protocols. There's all sorts of effective communication issues that come up. I mentioned interpreter services. There's many other types of assistive devices, technology, auxiliary aids, medical equipment that people may need as a reasonable modification to usual policies. And so those are some of the examples of how these legal principles apply in this context. And I'm going to turn it over to David to talk a little bit about the first complaint that was filed and how the law applied to the principles applied to what Washington State was doing.
Thank you, Jennifer. So I'd like to talk specifically about the Washington complaint. And so to start that, just explain who the folks were that pulled that together. We had claimants and advocates come together over a weekend. The newspaper started reporting about the actual particulars of the plan on Friday. So then by Monday morning, we had pulled together a legal complaint with the Office of Civil Rights at the Department of Health and Human Services. The complainants were, or the claimants were Disability Rights Washington. I work for them. We're a private nonprofit organization. We are the protection and advocacy system for Washington State. So whatever jurisdiction you are in the United States, there will be one of us. Northern Marianas has a protection and advocacy system all the way over to Maine. So everything in between. And we advance the human and civil rights of people with all types of disabilities, whether that's physical or sensory or mental health diagnoses or intellectual or developmental disabilities. We also had a claimant in an organizational claimant from Self-Advocates and Leadership, a statewide self-advocacy organization in Washington State that advances the rights of people with developmental disabilities, does a lot of public policy work, and we're going to hear from their chair in a moment, Ivanova Smith. And then also the National ARC, the ARC of the United States, the nation's largest organization of and for people with developmental disabilities and intellectual disabilities. They promote the human and civil rights of people with intellectual and developmental disabilities. And all of our groups really focus on inclusion and fighting against discrimination. And we had a number of great attorneys come together and think through these issues. Medical discrimination is not uncommon in the disability community. It's actually quite common. So that we pulled from years of experience dealing with these types of issues, whether they come up in policies around who gets organs during organ transplants, or they come up with who gets involuntary sterilization orders issued against them. There are multiple ways that the medical profession and disability the disability community view disability differently. And the Washington plans are a really good example of that. The Washington Department of Health and a group of hospitals got together and created a plan, as did the University of Washington's Medical Center. The plans were developed by doctors and bioethicists, as most of these types of plans are. They were made public only after there's local and national media coverage of this issue. There was initially some coverage of, oh, plans are in the works, and then the following day, the plan was actually handed to the media and we could see what was going on there. The Washington State hospital officials and the Department of Health actually described the plan as unthinkable. I mean, and I think most people in our society think, you know, we're in the US, we don't have to deal with these types of issues. But I think all of the work that's gone in over the years on emergency planning and preparedness has showed us that there's always a need to take very credibly the threats that come around. So while we've been able to deal with global pandemics in the past in a way that hasn't affected us here, today we're seeing that it is. So to jump into the plans, the Washington Department of Health guidance that was created with the Department of Health and the hospitals looks specifically at loss of reserves and energy, physical ability, cognition, and general health to decide who gets intensive care unit care and who gets referred to just go back home or receive palliative care. The idea of loss of reserves and energy, physical ability, and cognition as being, and general health as being the determining factors about whether or not you actually get the intensive care unit care you need, that's highly subjective. That there's a wide swath of how that could be applied. And we know that as advocates for equity, that the more discretion you give people, the easier it is for implicit biases or structural biases to get into those decision making. So we wanted to address any unchecked bias that might allow quality of life issues to come up. And I'll talk in a moment about the distance between how often people in the medical profession view value of life of people with disabilities and how people with disabilities themselves value their own lives. the University of Washington Medical Center's guidance was more narrative informed. The first one I just described was more of a flow chart of when this happens, then this happens, and had very broad categories, as I just mentioned, that you had to fill in the gaps. The University of Washington Medical Center was more narrative, and it was a little clearer, but in its clarity, it was also troubling. It specifically said that there was a priority for treating younger and healthier individuals, and allowing older and sicker, often associated with disabilities, to only receive palliative care, not receive the ICU care they would need to survive the COVID. And additionally, they focused on overall survival. That's healthy long-term survival, recognized by that this represents weighting the survival of young and otherwise healthy patients over older, chronically debilitated patients. That's their language. So again, there's an explicit distinction made on very general terms of health, youth. So the Washington complaint combined both our knowledge about the bias against people with disabilities found in medical settings with the anti-discrimination laws that Jennifer just mentioned, to go through and point out where improvements need to be made. So as Jennifer mentioned, with the reasonable modifications and the need to really focus on individualized determinations, one of the most important principles in disability advocacy and disability anti-discrimination laws is avoiding myths, stereotypes, assumptions, and instead focusing on specific individualized approaches. So we wanted to make sure that we were addressing the bias that sometimes comes in those assumptions. We showed that there are studies that show bias in the medical field, that there are trainings that medical professionals get that perpetuate bias that already exists in our society, that doctors often may even offer people with disabilities options to die when they wouldn't offer those same options to other individuals who don't have pre-existing disabilities when they come in. And some bioethicists are openly hostile to people with disabilities and the concept that rights should apply across the board to everyone. So within that landscape, we really wanted to push back on, if that's the framework in which people are coming at, and then they're told in a very general sense, look at reserves of energy, physical ability, cognition, and general health to decide who gets treatment, and look at long-term survival and focus on younger, healthier patients. And we know that there's this generalized bias. What do we need to do? So we really stressed, you need to have individualized determinations. That's not generalized assumptions. It's not assumptions based on quality of life or whose life is worth living. It's not about generalized survivability. It's about survivability of this particular crisis. Can you get better from COVID? Can you be released from the hospital after you get better? As Jennifer said, we're not talking about can you survive for 10 minutes after we've cleared you, but rather are you better, but not are we looking at 3 or 4 years out? And you must be, all of these decisions must be based on the best available medical evidence, not on generalized assumptions. So with that, I'd like to introduce Ivanova to talk about how this impacts, all of these issues impact SAIL members and why you came on board with this complaint to push back against our plan that had, that provided a lot of ability for medical folks to put their own biases into the system.
Yes, hello, I'm Ivanova Smith, and I'm the chair of Self-Advocates and Leadership SAIL. We are a coalition of leaders with intellectual and developmental disabilities, and we do legislative advocacy policy work to try to make sure that our civil rights are respected within the legislature. And we had a lot of concerns about this rationing. Many of our members would be greatly impacted by rationing. We have a lot of weaker immune systems, and we know that our community will be hit harder by this virus because of, we're just more at risk. And so it is really important that we are not denied medical care. I really am fearful of getting this virus because I don't want to be denied care, and I do not want my members to be denied care. We also know there is a long history of people with intellectual and developmental disabilities having their medical rights restricted. Like a lot of people put on the guardianships where they don't get to make their own medical decisions. There's been times where people have been denied treatment. They've been denied things like organ transplants and other life-saving care. And so we want to try to be proactive. And so that's why I worked with the SAIL membership and our rapid response team with David Colson to do this complaint, because we want society as a whole to see that we're speaking up for ourselves and we're saying, you can't be denying us treatment. That's against the ADA, that's discrimination, and we won't allow it. And you shouldn't base my life's worth on my intellectual disabilities. I don't think that's a fair way to assess that somebody deserves life-saving treatment. And so we're very passionate about stopping this discrimination from happening. And another part I would like to say is we also are working with the governor's office. We're telling them that they need to have self-advocates represented in these conversations. Nothing about us without us. We need to be at the table with these discussions and how we receive care, and we should not be excluded.
Okay, this is Alison Barkoff. Thanks so much, Ivanova, for sharing some of your perspectives. I'm going to talk a little bit about some of the other complaints, as well as the advocacy efforts that have been happening to get to guidance from the Office of Civil Rights, and then I'll touch on the Office of Civil Rights guidance. As Shira and David and Jennifer laid out kind of in the context, there's this long history of discrimination against people with disabilities in accessing healthcare in general. But as we were watching what was happening in the rest of the world, and particularly in Europe in late February and early March, where we started seeing rationing of care happening, we actually saw the kind of discrimination that we all feared. And by the time it was early March here, the disability community had very much activated around concerns about being denied life-saving treatment, and feeling very strongly that there needed to be a clear statement from the federal government, particularly the Office of Civil Rights within Health and Human Services, to states, to hospitals, and to other covered entities, really laying out what those obligations are. We knew as advocates and as lawyers, we could get out there and say that, but it's understood in a very different way when it comes directly through guidance from the government. By mid-March, there had been letters coming from the National Council on Disability, which is the independent federal agency that advises the federal government, the executive branch, and Congress on disability policy, imploring the Office of Civil Rights to put out guidance. And it was followed up a few days later by coalition letters from national groups, including the Consortium for Citizens with Disabilities. By the time we started seeing state policies come out, there hadn't yet been guidance, and we thought a really important way to kind of put pressure on the Office of Civil Rights and or give them some vehicles to put guidance out about what is legal and illegal was by filing complaints. And I think David was incredibly humble. It was a really, really, really fast moving 2 or 3 days. Most of the speakers, actually every one of the speakers who are on the screen right now were part of kind of pulling this together. And it was a strategy both to make a big difference in Washington state, which was incredibly important, but really as a vehicle to get some national guidance out so we could have an impact across the entire country. Within 1 week, building off of the incredible work that David helped lead in pulling together the legal analysis in Washington, we worked with stakeholders across the country. We really identified, what are some clear examples of the different issues that Jennifer laid out, where there were examples of plans where people were categorically excluded based on their disability, or heavily weighted, their disability was a negative factor that was weighted against them, or there weren't reasonable modifications to how long you could be on a ventilator, or even some examples of policies that would take a ventilator away from someone who would use that in the community. And within 1 week, this group, working with state advocates and the PNA, as David mentioned, the Protection and Advocacy Agency in each one of the states and other coalition members, had filed 4 complaints, one in Washington, Alabama, Kansas, and Tennessee. And that was all the week of March 23rd. So really in like 10 days, the pressure was really mounting. We were very pleased on a Saturday morning about, the days are moving so quickly and slowly, but it's only been about 2.5 weeks. The Department of Health and Human Services pulled together a press conference and released some guidance. And we think it's incredibly important that this guidance went out. I'm gonna talk through some of the principles that were in the guidance. We're still hoping that either through additional complaints or follow-up guidance, they'll get more detailed. But the guidance was incredibly clear on a couple of issues. The first thing is that the guidance said that the goal is to ensure that covered entities that are covered by Civil Rights Authority keep in mind their obligations to prohibit discrimination on the basis of race, color, national origin, disability, age, sex, and exercise of conscience and religion. So very clearly saying, despite being in a pandemic, despite being in an emergency, these civil rights laws continue to apply. And when talking about the ones relevant to people with disabilities, the ones Jennifer spoke about, so Section 504, Section 1557 of the Affordable Care Act, and the ADA that prohibit discrimination, they very clearly said, to quote, these laws remain in effect. So to the extent that there was some conversation in the media that or concerns that civil rights laws were kind of put aside in emergencies, this guidance made very clear that's not the case. So there were 3 pieces discussed in the guidance itself, and this has really been an effective tool for us in kind of follow-up advocacy. The first thing is exactly what Jennifer said, and it's incredible when Jennifer says it or other advocates say it, but for HHS to be very clear about what constitutes illegal discrimination. And they specifically talked about when people are denied medical care on the basis of stereotypes, assessments of quality of life, or judgments about a person's worth based on the presence of disabilities. The second thing that they said is, as Jennifer mentioned, a core principle of disability anti-discrimination law is that there must be individualized assessments. So being clear, the guidance said that decisions concerning whether a person is a candidate for treatment, or using the legal words, whether they're qualified, has to be based on an individualized assessment of the patient based on the best available objective evidence. And then the third piece, as Jennifer talked about, are the legal obligations that covered entities have to make reasonable modifications to ensure equal access. And there are a lot of examples included in here about effective communication for people who may be deaf or hard of hearing or blind, interpreters for people with limited English proficiency, plain language in multiple formats, accommodating people with physical disabilities, mobility impairments, speech impairments, people who may be immunosuppressed. So the important thing is this guidance really laid out the basis for all the things that we had been out there saying. Just to touch on the couple complaints and some of the topics covered. As Jennifer mentioned, our complaint in Alabama focused on the categorical exclusion of people with intellectual and cognitive disabilities, as well as some exclusions based on age. In Kansas, there were also categorical exclusions, based on disability diagnosis, and those included neuromuscular diseases and advanced immunocompromised disorders, certain cancers, and then a policy that people who were living in the community and using ventilators, if they came in for COVID-19 treatment, that their ventilators could be taken away from them. So incredibly concerning. In Tennessee, it was pretty similar to Kansas in terms of some of the categorical exclusions, but also referred to certain disabilities where people might need assistance with activities of daily living, which really gets to the core of kind of quality of life issues. The fact that you might need someone to help you bathe or cook has nothing to do with the fact of whether you can survive and benefit from the treatment. In Pennsylvania, there has been a complaint filed where they rely very much on long-term survivability, and the scales that they use heavily weight the fact that you have a disability in ways that are related to immediate survivability. Utah had some categorical exclusions, and New York was similar to Kansas in terms of reallocating vents. So in addition to the guidance that came out from the Office of Civil Rights, we have a second announcement that came out just this week from the Office of Civil Rights that provides really more guidance across the country. They resolved the complaint that we had filed with the Office of Civil Rights through a process that they call early case resolution. And I'll just say, as someone who's worked in the federal government and enforcement agencies, the fact that in a little more than 2 weeks, they were able to quickly resolve something and put something out, I think really explains the urgency that I think we've convinced them of, certainly, and that they see in addressing these issues. The OCR early case resolution laid out, I think, 2 principles that are legal principles that are applicable and that we've been using across the country. First of all, it said that the policy was illegal because it categorically excluded people because of their diagnosis. And in this case, it was intellectual or other cognitive disabilities. And it also had some really important principles in there around categorical exclusion based on age, and saying that also is illegal when they set strict age cutoffs and completely exclude people. So I think after the Alabama complaint, there's actually even more out there around age discrimination. Through this complaint process, this resolution, Alabama agreed to withdraw the policy, gave notice across the state that the policy had been withdrawn, instructed hospitals across the state that they had these non-discrimination obligations. Stakeholders in Alabama are continuing to push for more detailed non-discriminatory standards of care. Right now, there aren't detailed standards of care, but it created an important legal precedent. And I'm just going to touch for 1 minute on, while a lot has been done through kind of a more adversarial complaint process, I would say most of the advocacy that's actually happening across the country is in kind of disability coalition, sometimes broader than just disability groups, and sometimes with healthcare groups and aging groups and racial justice groups, affirmatively working with governors and leadership in states to work to either revise existing policies that have discriminatory provisions in them, or to affirmatively develop new policies. And I'll point to a few examples where advocacy has made a huge difference. A huge group of stakeholders, cross-disability, racial justice, and aging groups in Illinois have been working very hard. The governor just in the last few days put out a pretty detailed order of non-discrimination based on disability and race and insurance status, and is working, and hopefully in the next few days we'll be putting out some new standards of care. In Colorado, there was a coalition, and the state working with that coalition really changed a lot of things that had been in the earlier policy, and they agreed to no categorical exclusions, no reallocation events, made a lot of commitments around accessibility, and that plan was actually adopted through an executive order, so it mandatorily applies across states. And we're also seeing, just related to, I think, one of the biggest access issues, and David mentioned this, and what we're hearing from people with disabilities and family members is the need for making reasonable modifications to no visitor policies. And that is one place where advocacy has made a really big difference. Just in the last week, New York issued a statewide policy that was very explicit about a number of circumstances where the no visitor policy, there would be exceptions, and that people with disabilities who need a support person, if it's essential if it's medically necessary or otherwise essential for communication and other reasons, can have a support person. There's a great policy that came out of Chicago, and a really, and one in Oregon that's narrower, and I know people are working to make it broader, but I would just kind of end by saying that this is, even 2 weeks ago, where we were is a really different place than where we are now. I'd say, just guessing, we're probably working with stakeholders in about 25 states between OCR complaints and stakeholders working with governors. I think Sam is now going to talk about the tools we've created, because we think it's really important for stakeholders to have tools to do the best they can to make changes through their advocacy.
Great, thanks. Thanks, Allison. So I'm Sam. I'm the legal director of the Autistic Self-Advocacy Network. And I will start by saying that as around the week of the 22nd or so, when we were filing all of these complaints, there was so much going on. A lot of states were reaching out and talking to us about their policies. We really started realizing that we needed to engage state level advocates on this work. The plans were coming out at the state level and even at the hospital level. They're incredibly technical, and state level advocates who were already on the ground trying to work on these and make them better were reaching out and asking for guidance on how to read the plans and recognize when a policy was permissible or impermissible. So for example, automatic diagnosis-based exclusions, you've heard from Alison, from Jennifer, and from David, those are not allowed, even if they're phrased as survivability as triage. Anything along the lines of quality of life determinations, anything that looks like a decision about whether or not someone's living independently. And so we came out, we started with guidance to states and healthcare providers on how to avoid disability-based discrimination in treatment rationing. So we wanted, the OCR guidance was really helpful, had some really good language, but it wasn't incredibly detailed about exactly which kinds of provisions would and wouldn't be allowed. So we put together a quick guidance that is available on the Center for Public Representation website, and I'm gonna put it in the chat box. But we started with sort of guiding principles. All lives of people with disabilities are worthy and worth saving. People need to have equal opportunities to receive life-saving treatment. The fact that a person might need support for independent living is not relevant. We shouldn't use assumptions or stereotypes or bias. And the importance of individualized review, the importance of not reallocating ventilators that a person is already using in their daily life, and of course reminding people that the federal disability rights laws still apply. We went into specific examples of we went line by line in the OCR guidance and fleshed them out with specific examples. So for example, the OCR mentioned that there needs to be a non-discriminatory policy, and we gave as a specific example that triage plans need to include a specific affirmation of non-discrimination, make sure that all relevant personnel have training in non-discrimination, and the importance of making these plans available to stakeholders and accountable to stakeholders. We, specifically went into guidance on you can't have a diagnosis acting as an exclusion. You need to make reasonable accommodations, and here's some examples of reasonable accommodations you need to make in your plan. If you, for example, if you want, you can't use HIV status as a proxy for deciding who's immunosuppressed, because many people living with HIV are not actually immunosuppressed because of effective management of HIV. The importance of making effective communication available to people who are arrive at the hospital. We later realized that we needed to go even further into detail for state advocates who are evaluating plans, and we published a guide for evaluating plans. Also on this on the website I linked, and it goes into examples of, for example, how to tell whether your plan is talking about ventilator reallocation. Sometimes this is hidden by saying that people on ventilators are just going to be subjected to the same triage guidelines as everyone else. And that means that actually does mean that you might end up taking a ventilator away from someone who's already using it. Ventilator reallocation policies also happen where someone is put on a ventilator at the hospital, they're not improving, and you make the choice to take them off the ventilator so that you can offer that ventilator to someone else. And we talk about in this guide, like the importance of making reasonable modifications to that policy. So someone with a disability might need just a little of extra time on the ventilator in order to benefit, and they shouldn't be denied that. And we even go into sort of technical advice on how to evaluate survivability guidelines. There's something called a SOFA score that is supposed to measure the severity of someone's illness. but it includes a question like, for example, does this person need mechanical ventilation? That could be a measurement of how severely ill someone is, but if a person was already using mechanical ventilation before they got sick because they're a person with a disability and they used a ventilator long term, then it might not reflect the severity of the illness, and you shouldn't be necessarily factoring that into the SOFA score. You need to be basing it on objective medical evidence. I also think, you know, if you go to the website that I put in the chat, you can also find a collection of law review articles, articles by medical ethicists, statements, a really useful statement by the American College of Physicians, and of course, copies of a lot of complaints and letters to the governors. If you are a local advocate and you want to be part of participating in a complaint or valuing your state or hospital plan, the website is a really good way to not only find resources like I discussed that will tell you how to evaluate the plans, but also give you some sort of ideas of what complaints have you know, like some of the language that we've put into complaints and some of the approaches that are available. I also want to talk about the importance of media advocacy to this movement. We're really grateful that the media has been very responsive on this issue. I think it's a compelling, you know, it's a compelling narrative that, you know, when we're in crisis, who gets left behind and who gets denied care. I think it seems to be really interesting to the general public, and we got a lot of high-profile media coverage from the very beginning of this process. And when we filed a Washington complaint, we got picked up not only by quite a few Washington newspapers, but also places like NPR, the Bloomberg, US News and World Report, the New York Times, and other pretty big media sources. The importance of media coverage, it has a few different effects. One is it helps obviously raise awareness of the issue among the public, but also helps frame the narrative and humanize the effects of the policies. It can also help put this on governors and hospitals' priority list because they have a lot to think about right now. And the more media coverage we get on this issue, the more the governors and hospitals realize like we have to actually pay attention to this and get this right because the public is paying attention. Vent reallocation is a really good example. So for example, in New York, the reallocation guideline that said that vent users who came to the hospital might be taken off their vents, it was sort of buried in an otherwise pretty good policy. And the justification, the way that they framed that guideline, was they said that if you don't subject long-term vent users to these triage guidelines when they come into the ER, the result would be an unfair to everyone else because the vent users would be getting special treatment and they would be getting vents when other people wouldn't be in the same situation, wouldn't be eligible for them. When we got really good media coverage of that policy, it helped contest the framing and instead focused on the perspective of long-term vent users who were scared to go to the hospital for fear of losing the supports that kept them alive. And once you sort of reframe it in that way, it becomes much harder for hospitals to justify or for the states to justify that policy. We also got really good coverage when HHS did put out its bulletin. We got covered again in NPR, Times. And again, that's really helpful because it's free outreach to people at the state level and local advocates so that they can know that this is happening. They know that there is a bulletin. They can then look it up and send it to anyone who needs to be made aware that in fact the law still applies in this crisis. At the state level, media coverage can also help advocates identify exemplars. So I know, for example, people have reached out to us who had read some of the media coverage about the complaints. So they reached out and they, expressed concern that either they or their family member would experience discrimination. And if you are looking for, if you are as, a protection and advocacy organization, or you're a local nonprofit that's participating in an effort to change these triage plans, then finding exemplars can be really helpful to moving things forward and pushing back on bad plans. Thank you. I don't remember who goes next.
I think that's all from all of our panelists, but we got a bunch of questions. So we're gonna try to get through those as best we can. Feel free to keep putting them in the Q&A and I'll do my best to monitor. And thanks to all of our panelists, and thanks to everyone for participating in the sending questions. So let's get started with some questions. So this one, there's been some questions about reasonable modifications and how that actually works in this context. So specifically, what kind of guidance exists to define the word reasonableness in this context? There are concerns that accommodations that are typically accepted, like interpreters, will be viewed very differently from something like needing more time on a ventilator than another person. How do we as advocates address that? And then there was also a specific question about a reasonable accommodation that was mentioned around having a personal care attendant or family member, a disability service provider of some kind in the room as a reasonable accommodation, and how that would actually work, who provides that accommodation. So I don't know, Jennifer, I know you spoke about the legal framework. If you want to take that question or those questions, and others can obviously chime in.
Sure. So others can jump in too, but I guess I would say, I mean, it's an excellent question. And I think, what's reasonable always depends on the particular circumstances at hand. That's the, I suppose, the benefit, and also in some ways the confusion of having a very broad law or set of laws like disability discrimination. They were defined, they were written very broadly to anticipate many different types of circumstances. So that's why, they're not written with precision, but that doesn't mean they don't apply. That is exactly the reason that we wrote the guidance document that took what OCR had done, the Office of Civil Rights at HHS, and took those principles of law, non-discrimination, individualized assessments, reasonable modification, and actually explained more how they would play out in these circumstances. And so, for example, in that guidance document, I think it's on page 7, I might be wrong about the page, I think it's page 7, is the example about needing the ventilator for a longer period of time. There are many other examples in that document of reasonable modifications, including sort of the visitor policies and interpreter services and all types of other accommodations. That's not an exhaustive list, certainly. It will not help every single person, I think, if their particular issue is not discussed in there. But the purpose of that document was to give people something that they can take, that they can rely on, and and use in advocating with a hospital or even a state, but you know, if they're finding themselves in that circumstance on the ground with a hospital, to say, no, this is a reasonable modification, and you know, we can obviously help further. People should reach out to their protection and advocacy systems, as others talked about, and ask for help. And I think the PNA network is now very well versed in these issues, but that is why we're trying to get the word out in detail as much as we can, I think. So, and I think in terms of other types of accommodations, what was I going to say? There's, I think some of the complaints actually talked about that. Oh, I know what I was going to say. The visitor policies actually that are on, they're on the CPR website, the Center for Public Representation website, and you have the link here a few times. Those policies, I think, are good examples. If you run into an issue of visitor policy and a hospital that says, sorry, you know, this is our policy and we can't change it, I think having those examples of here are states that actually have put in writing, you know, that these are reasonable modifications, and here's a hospital that's done that, I think helps make the case to other places. So others may have additional comments.
And I will say in our evaluation framework, we do specifically list some of these proposals as possible reasonable accommodations. Unfortunately, of course, the way the ADA works is that reasonableness of an accommodation is very, very context specific. And it's hard to say whether extra time on a ventilator is always going to be a reasonable accommodation. You have to look at, you know, the nature of a person's disability. Is there a medical reason to believe that the person would benefit from extra time on a ventilator if they haven't already? What, you know, exactly how much extra time are we talking about? You know, what's the hospital situation might end up becoming relevant, or is there an undue burden concern? And you know, you have to really look at the individualized circumstances. It's going to be really hard to address exactly when, you know, moreover, it's a case of, you know, it's a case of first impression. There's no case law on exactly how long in a pandemic, you know, when extra ventilator time is warranted and when isn't. So it's something that advocates, you know, are never going to know whether they're going to win that argument, but it's very important to make it anyway.
And this is David. To that, the idea of a reasonable modification goes to the very point we're trying to make, that these all need to be individualized determinations. So while you can't draw a hard and fast line on what is and is not reasonable, that's the whole point, is you also can't draw a hard and fast line that 5 days on a ventilator is what you get, because that's what the average person needs. And if they're not getting better, you're not going to get better. Make an individualized determination. And there are lots of resources on the Center for Public Representation page link that was there. There's also stuff from bioethicists. So we look at this through a legal framework, but doctors and other bioethicists talk about this from a bioethical framework, and they're often using utilitarianism as if there is a mythical, most efficient, most maximal benefit for each resource that can be allocated. And there's a bioethicist who pushes back on that a little bit, Joe Stramondo, a professor in San Diego, who says we can't conflate waste, where we're allocating a resource towards some effort that is futile, where there is going to be no real benefit, to something that may not be maximally efficient. There might be some inefficiency in it. And if you have a hard and fast rule that says 5 days is what you get for ventilators, and if you haven't improved by then, we're taking you off. That's really focusing much more on the how do we maximize efficiency and churn people through the system, and if they aren't keeping up, we're leaving them behind, versus if we thought you could survive, let's keep assessing that, and are you going to survive? And we got to day 5, but you know what? We think you might get there if we do 2 more days. Let's reassess this tomorrow and the day after and see where we're going. That's individualized. I guess to some of the other questions we've been getting about how do you do that individualized treatment? How do you focus on the best available medical information? If what we have, and we show that if you are scoring this way on your breathing tests, or we're doing some other measure of your prognosis, and we know that people who test this way have a 75% chance of survival. People who test this way have a 25% chance of survival. Science can show us there's a big split there, but because there's statistical significance in this score versus that score. But if instead we're using generalized assumptions of someone who comes in with asthma or an underlying cardiac problem generally doesn't do as well as someone who doesn't come in with those underlying conditions. That's not individualized, and it's not based on our best scientific knowledge of how this particular disease process works. It's based on a generalized assumption that, yeah, generally if you don't have an underlying cardiac condition, you're going to bounce back better from an infection than someone else. But that's how much better and how fast and what would it actually take, and will you actually die from it, or it'll just take longer? If we don't have science that helps us answer those questions, then let's not pretend that we do and make generalized rules based on assumptions.
Thanks, everyone. So moving on to another question. Can you speak to how the HHS guidance and state and federal disability rights laws interact with laws that shield doctors and hospitals from liability? And how do we address that?
I can start, and maybe some other people want to jump in. We have been looking at this both in terms of federal emergency laws. There's actually one specifically mentioned in the Office of Civil Rights bulletin, as well as we're hearing about some of these kinds of provisions being passed at a state level. Certainly from what we've looked at least in the federal law, the PrEP Act that's referenced in here, lots of those are kind of focused on tort kinds of liability. So doctors not being able to be, or even people producing medical equipment not being able to be sued for money damages. I think our position has been looking at the purposes of these laws and the very clear guidance from OCR that, federal civil rights laws remain in place, that we think that doesn't cover things like injunctive relief, which is really what, if we had to go into court, we'd be seeking. The Office of Civil Rights has certainly made clear from their own perspective, none of these laws limit their ability to enforce. So I kind of wearing both my advocacy hat as well as kind of the best legal arguments hat, I think we have not yet seen that defense in a court case. But it is something that we are trying to navigate, and we think it's really important. And this has been some of our coalition work, not just within the disability community, but across the broader civil rights community, to make sure that if there are any kind of emergency waivers of liability, it cannot be a civil rights and civil rights enforcement.
Yeah, and this is Jennifer. I would just add, I think to the extent that these are state laws, to the extent they are inconsistent with federal laws like the ADA and 504 and the remedies that those laws provide and the rules those laws provide about liability, I do think that they're preempted by federal law. They should be preempted. And so, if a state passes a law that says, you know, during a pandemic or during an emergency crisis situation like this, you know, there's not going to be liability for manufacturers or people who are involved in the generally in providing medical treatment. That may immunize people from liability to certain state claims, but you know, if a hospital says we're not going to give ventilators to anyone who's African American, or you know, we're not going to give ventilators to anybody with an intellectual disability, I think that, you know, these are federal civil rights laws that apply, and I think that they should preempt the state law in that circumstance.
This is Sam. I just got a message on this. Apparently, HHR has just let advocates know that they're planning on issuing further guidance on PCAs in hospitals and sign language interpreters and communication aids. So that's something to look forward to.
And Sam, you said HHS OCR is going to be? Yeah.
OCR just said this on a call that's going on at the same time as this.
Okay.
This is Ivanova. I would just say we want to make sure that the state laws respect the non-discriminatory, the laws against discrimination federally and locally, that, and also that there's also people that are dying from other medical complications that they're not getting proper care for. We've actually just lost a number of people first of Washington to not getting proper medical care. And so this is something that it's not just people getting COVID-19, but this impacts people who have other medical conditions. And we need to make sure it doesn't discriminate for any medical condition.
And you know, this, you know, COVID-19 is still not going to be, even if we're talking about, you know, ventilator reallocation, not everyone who comes into the ER needing ventilation has COVID-19. So it's going to impact quite a lot of the community.
Thanks, everyone. Some other folks have raised questions about, you know, this is really great advocacy work and it's so important, but how can people with disabilities who are going, you know, have to go to the hospital seeking treatment, make sure that these principles are actually applied? One thing, I'm sure a lot of folks have something to say to that. I mean, one thing I would say is, one, you know, part of what we're doing is trying to get the word out extremely widely through things like this program, through the complaints. The media, as Sam mentioned, has also paid a lot of attention to this issue. And so a big part is trying to take as preventative approach as possible and really providing resources to both states and hospitals that are developing these plans and making sure that doctors and other medical personnel are properly informed, so that there's less of an, you know, burden on obviously the patient who is ill, and dealing with those issues. But there are also some Know Your Rights materials that have been created, and we're just trying to create as many resources as possible to both bring attention to this issue and help people know in various situations what they can do to enforce their rights. So I have thoughts too.
In Washington State, we have been creating plain language documents for self-advocates so that they can understand their rights. We have a DD ombuds here in Washington, and so they have been working, calling all the clients that are under DDA, the Developmental Disability Administration, and checking up on people. They've also been a resource for people when people do have to go into the hospital. They can send the DD ombuds can help them know their rights in that situation. And also we create Playing Informing Families has been working on materials to help people with intellectual and developmental disabilities know what's going on with this medical stuff and what to do. And so, and one thing we've been trying to encourage at the governor's office is to have people with intellectual and developmental disabilities be represented in oversight for the triage teams, or be able to provide training on true equity in disability justice to the triage teams. So those are some of our strategies.
And this is Jennifer. I know there are some other Know Your Rights guides too. And I know DREDF, the Disability Rights Education and Defense Fund, has a nice one on their website. That's like a one-page document that lays out some of these things. And some of the other state-based coalitions have done them. I know in Tennessee, they did one, the Tennessee, Disability Rights Tennessee, and some of the other advocates there have those on their websites. But and there are some, I don't know if there's any of the Know Your Rights ones on the CPR page, Alison.
Yeah,
Alison.
on my list to add, but yeah, the best ones right now, DREDF has one, SABE has done one, and there have been a couple really good ones that came out. There was an ACL funded center that put out a plain language one targeted to medical professionals based on the HHS guidance that also was good. And I can work on adding some of those. They're not there right now.
Thanks, everyone. Another question that's come through is, does the guidance from HHS and some of the advocacy efforts also include tracking the health disparities of people of color with disabilities? And if so, what kind of tracking is going on there?
So one thing that that I can mention, and I think it's especially come into focus over the last 2 weeks or so as the impact on communities of color and the disparate impact has really been clear with the COVID virus. So a couple things. One is there has been a big push both from members of Congress and from a lot of advocacy coalitions that include people with disabilities, a lot of broader civil rights coalitions pushing for the collection of data. There was a letter from about 2 weeks ago that came from Senators Warren and Harris and Booker and Ayanna Pressley and Kelly, Representative Kelly, really urging the CDC to begin collecting some of that data. There are places, and Illinois and Massachusetts are two where there has been a lot of focus on racial impacts in terms of the policies that have come out. I thought the Illinois statement from the governor was really good in looking at kind of impacts by disability, racial issues, as well as kind of economic issues, and a very broad coalition of stakeholders from a lot of justice communities are working together with the Illinois leadership on the crisis standards of care that I hope will be quite explicit on that. In Massachusetts, there's a very broad coalition, and part of their asks have really been focused on that, both in terms of data collection and making sure that the standards of care don't have a disparate impact on communities of color. So those are some things. Jennifer, there's some other ones.
Yeah, I think on a national level too, the civil rights community has started to raise these issues. And I know that in particular, the Leadership Conference for Civil and Human Rights and the Lawyers Committee for Civil Rights are writing to CDC and I think FDA, pointing out the dramatic consequences of not having the data. They were focused on racial and ethnic disparities that seem to be coming out pretty obviously from all of the news articles, as Alison mentioned. We began a conversation with them to also integrate the disability disparities too. It seems that, in part because of all the congregate living environments and institutional settings, that there really has been a disproportionate impact, not just because of sort of pre-existing vulnerabilities maybe, but also just because of the living environments that so many people with disabilities are in. That there seems to be a disproportionate impact on people with disabilities in terms of them getting it disproportionately and also dying disproportionately. And so I think the civil rights folks were very interested in integrating disability into those existing efforts to try to get some of this data collected.
And I know that the weekend before working on this rationing thing, I was working with some other protection and advocacy lawyers from around the country to draft a request to the federal government for demographic information of who is getting access to testing, not just on disability status, but multiple marginalized statuses that because of the health disparities that are pre-existing, we anticipated would be perpetuated in their access to testing and therefore access to treatment. We still haven't received any answer to that request, and that was made about a month ago now. So I think this is going to be an issue that we need to keep focused on. Here in Washington, Ivanova and I, as Ivanova mentioned, are working with the governor's office and Department of Health, but we have a coalition that we're working with that is looking at race equity, disability, and age, because all of these groups are very explicitly, easily identifiable. They're going to be receiving poor responses here, poorer responses than the majority. Additionally, we know that the HIV/AIDS community is interested in this issue as they routinely face stigma in the medical profession and generalized assumptions about compromised immune systems. And we know that immigrant communities have a harder time accessing healthcare given the various barriers we put in place for them, and of course language barriers as well. So multiple groups that need to be joining forces to be pushing back, whether it's rationing or anything else related to this healthcare crisis. If you are a member of a community that typically is not served well by our institutions and our culture, our institutions are not going to be able to make up that difference during this crisis. If anything, it's going to be exacerbated, not ameliorated, without strong advocacy.
And I'll just mention one other thing, which is some of the leading voices in the disability community and who have been most vocal in media also come from multiply marginalized communities. And I'll specifically mention Alice Wong has really been, I'd say, an incredible voice of the community in terms of the real palatable fear of what these policies mean, how they would impact her as a person with a disability, who uses a vent, who's a person of color. And actually we were hoping to have her on today's webinar, but she wasn't able to make it. I think it's a really, really important perspective, and especially as important as we're seeing just the most unequivocal data about, the impacts on just communities of color. And so I think as we move forward, the coalitions that we're building, being built 4 weeks ago, and some of the focus there look really different than the ones that have been coming together over the last 2 weeks. And like I said, I'm hopeful that we will see some plans that we can point to as models on looking at the various lenses of communities that are impacted. And we do not yet have a plan that I'm aware of that really does that well yet.
Well, that about concludes our time today. Thank you so much to everyone for joining. We hope you enjoyed the webinar. For additional information on the section of civil rights and social justice, please visit americanbar.org/CRSJ, where you can donate to support this sort of programming and find out more about the section's activities. And we also, there was a lot of requests for resources. We have centralized those resources and are continually updating them on the pages that we circulated. So those were sent around both in the chat and as well as the Q&A, and they're also available on the ABA CRSJ website for the webinar. But you can also follow up with any of us or the organizers if you missed any of those links, but check back for updates on those. And thank you so much to everyone for participating today, and stay healthy, everyone.
Thanks.
Thank you.